Good morning, everybody. Thank you for joining me for today's webinar. My name is Amber Hines, and today we're going to be talking about planning for married couples with annuities. So when each spouse would consider purchasing an annuity, both the community spouse as well as the institutionalized spouse. If you have any questions during today's webinar, feel free to type those into the questions tab of the GoToWebinar dashboard. And then also, if you're interested in the handouts from today's presentation, you can find those in the GoToWebinar dashboard as well under the handouts portion. Again, my name is Amber Hines, and I have been working with elder law and estate planning attorneys for the last 15 years. And my primary focus is working to help clients who are already in a long-term care situation or with Medicaid crisis planning, specifically with Medicaid compliant annuities. I'm insurance licensed in all states, and I hold my Series 65 license with FINRA as well. And I created Ashfur to assist advisors as well as attorneys with pre-planning solutions and crisis planning solutions from A-rated insurance carriers. Some of the reasons that you may consider working with myself and working with my company Ashfur is we have, like I said, been working with elder law and estate planning attorneys across the country for the last 15 years on Medicaid compliant annuities for their clients. We assist with complementary case analysis, which means that we will help you to determine the optimal amount to put into an annuity, the annuity term, and which assets your clients may consider annuitizing. So if there's assets that are pre-tax accounts, such as retirement accounts or IRAs, we can look at whether it makes sense to annuitize those assets or use other accounts like existing life insurance or annuities that have deferred gain or a low basis. We work with A-rated insurance carriers, and we provide top-notch customer service, getting back to you usually the same day with a recommendation or with a proposal. And so if you have any questions about working with us, feel free to reach out to me either through email or phone. Like I said, today we're specifically talking about Medicaid crisis planning. So when one client is already in need of long-term care, we're going to look at the solutions that we can consider for married couples in order to preserve as many assets as possible and still obtain Medicaid eligibility for the Medicaid applicant. When we are looking at Medicaid crisis planning, the goals that we are trying to achieve is to convert countable resources that Medicaid considers to be countable assets into non-countable or exempt assets in the most cost-effective, tax-efficient way. We're always going to consider what are the tax consequences in order to liquidate retirement accounts or to transfer ownership of a retirement account. And if the tax consequences are so large and the client's longevity is questionable, it may make sense to just not do an annuity at all, but to just continue to privately pay and hold off on doing the annuity until we have a better handle on the client's longevity. So there have been situations where we've said it doesn't make sense to incur such a huge tax bill if we're unsure how long a client will survive. Also, we're looking to minimize or avoid estate recovery as well. When we talk about a married couple, we have asset and income limitations like any other means-based program. So when we're looking at the income limitation for a married couple, the income limitation really only applies to the Medicaid applicant, and the Medicaid applicant's total income must be less than their cost of care unless you are in an income cap state or a state that says that the client's income cannot be more than around $2,500 right now is the current income cap. If you do live in a state that is an income cap state, then the client will, or the Medicaid applicant will need to establish a qualified income trust or a Miller trust in order for their income to flow through that trust and to basically get around the income cap of around $2,500. The community spouse is entitled to unlimited monthly income. There is no cap on the amount of income that the community spouse can receive. When we look at the asset limitation for an institutionalized spouse, the most common asset limitation is around $2,000. This does vary slightly by state. Missouri is around $5,000. New York is a lot higher than that. But the most common number is $2,000 for the Medicaid applicant. The community spouse is entitled to either 1/2 of the couple's countable resources as of the snapshot date or the first continuous period of institutionalization, up to a cap amount of $137,400. So there are some states that are considered to be high-low states. That is a state that we would be taking 1/2 of the resources up to $137,400. And then there are some states like Illinois and a handful of other ones that just have one standard cap amount and they don't make us divide the total resources in half. So if you have questions about how your state handles what the community spouse is, or the amount that the community spouse is able to keep, feel free to reach out to us with those types of questions. Some of the other resources that are considered to be non-countable for Medicaid eligibility purposes is the primary residence or the home, an automobile, household goods and personal property, an irrevocable funeral trust or burial policy. And then some states do consider IRAs to be non-countable assets or retirement accounts in general. They can be employer-sponsored plans that Medicaid does not consider to be countable assets that need to be liquidated or spent down in order to achieve Medicaid eligibility. If your client has excess assets, we generally develop a Medicaid eligibility plan, which can include increasing or improving non-countable assets. So making improvements to the family home, purchasing a new car. Also, we can consider purchasing prepaid funeral policies. If there's credit card debt, a mortgage, or other debt that the family has, we can spend down assets that way as well. And then after all of these items are considered, if there are still countable assets that need to be spent down, we can consider purchasing a Medicaid compliant annuity that would comply with the Deficit Reduction Act of 2005. A Medicaid compliant annuity is always going to be a single premium immediate annuity, meaning that it is an income stream. It is not a tax deferred annuity. A tax deferred annuity is always going to be considered an asset for Medicaid qualification purposes because it does have a surrender value or a cash value that the client can contact the insurance company and surrender the contract for cash. Whereas if they purchase a single premium immediate annuity, it no longer is able to be surrendered once we annuitize an annuity. Is strictly an income stream. SPIA is a contract that's used by insurance companies in order to convert excess countable assets into an income stream. And as a result of the Deficit Reduction Act of 2005, immediate annuities must meet very strict requirements in order to be considered Medicaid compliant. There are hundreds of insurance companies out there that offer immediate annuities or convert countable assets into an income stream, but there's less than 10 companies that offer a Medicaid compliant contract. In order for a SPIA to be considered Medicaid compliant, it must have all of the language that you're seeing on the screen here. It must be completely irrevocable, meaning that we can't change any aspect of the contract. We can't change the payment amount, the payee, the owner, the beneficiary. Nothing within the contract can be changed with a truly irrevocable Medicaid compliant contract. Also, the annuity must be non-assignable, meaning that we can't assign the annuity to a company like JG Wentworth or Peachtree that buys annuities on the secondary annuity market. The annuity must also make equal payments without any type of balloon payment at the end or a large payment at the end. The annuity must be actuarially sound, which means that the annuity must provide income back to the Medicaid applicant or the spouse within their Medicaid life expectancy. It can be structured for a shorter period of time than the full life expectancy, but not longer than the life expectancy of the annuity purchaser. And then finally, the state must be named as a remainder death beneficiary. In the event that the annuity owner passes away, the state would have a right to recover against the annuity to the extent that they would provide Medicaid on behalf of the Medicaid applicant. There are a couple of exceptions to that, and we're going to be talking about when the state must be named as a primary beneficiary versus a secondary or contingent beneficiary in today's presentation. The different types of assets that can be used to purchase a Medicaid compliant annuity, it's really any type of liquid asset. So if clients have money in checking accounts, savings accounts, CDs, stocks, bonds, brokerage accounts, whole life insurance, non-qualified annuities, or IRAs or retirement accounts, any of these types of accounts can be used to purchase a Medicaid compliant annuity. If your client does have money in stocks, bonds, or brokerage accounts, those accounts would need to be liquidated to a cash position before the annuity can be purchased, because we're not able to do an in-kind transfer of stocks and bonds into a Medicaid compliant contract. If your clients have whole life insurance policies or non-qualified annuities and they're contracts that were set up several years ago that have a lot of deferred gain or interest within them, we can do a 1035 tax-free exchange of existing life insurance or annuity contracts from the existing policies into a Medicaid compliant annuity. And the advantage of doing that is that we're able to spread out the tax consequences of the existing annuity or life insurance over the course of the time frame that the Medicaid compliant annuity is structured. And then finally, if your clients have IRAs or retirement accounts that Medicaid considers to be a countable asset in your state, we can do a direct transfer or a 60-day rollover of the retirement account into a Medicaid compliant annuity, so that, again, the tax consequences are going to be spread out over several tax years based on how long the annuity is structured, versus liquidating the retirement account and having to pay all the taxes in 1 year. So if we look at ownership or changing ownership of any of the accounts that we just talked about, from husband to wife or vice versa, all of changing ownership on all of these accounts can be done pretty easily without a whole lot of tax consequences, with the exception of IRAs or other retirement accounts. We're not able to change ownership of retirement accounts without the owner having to pay immediate taxes on the retirement account. So if we have like an existing brokerage account or non-qualified annuity, life insurance, that type of asset, we can change ownership on those types of accounts from the Medicaid applicant over to the community spouse pretty easy. Whereas if we have a IRA that's owned by the Medicaid applicant, we're not able to just transfer ownership to the community spouse without having any tax consequences, because those accounts have never been taxed before. So first, we're going to be talking about traditional community spouse annuity planning, and we're going to be first talking about a case that does not involve any type of retirement accounts. This is going to be money that's sitting in checking or savings, and it's a pretty liquid asset that we're going to talk about first. When we're talking about a married couple scenario, we're really, in most cases, talking about one spouse that is in a facility or the Medicaid applicant, and one spouse that is still residing at home in the community. The goals when we're planning for a married couple, when one spouse is the Medicaid applicant and one spouse is the community spouse, is we're trying to obtain immediate Medicaid eligibility for the Medicaid applicant or the institutionalized spouse without any type of penalty period or private pay period. So we want to get the Medicaid applicant immediately onto Medicaid by converting the couple's excess countable resources into an income stream. And then we also want to provide the community spouse with sufficient income and resources so that they're able to maintain their lifestyle within the community and they're not having to spend all of their assets on the Medicaid applicant's cost of care. Our case facts here involve Roger and Nancy. Roger is 85 years of age. He has dementia and resides in a nursing home. He has monthly income of $2,000. His monthly nursing home bill is $10,000 per month. And Nancy is the community spouse who is 83 years of age and has monthly income of $1,000 per month. The couple have a home, a car, and $300,000 of non-IRA bank accounts. With the couple spending $10,000 per month on Roger's care, they're going to exhaust their entire life savings within 30 months if they do no planning at all. And when Roger passes away, Nancy will be left with limited assets and nominal monthly income. So instead of not doing any planning at all, we're going to implement a Medicaid eligibility plan for them. And this is first going to be that we have to calculate what the spend down amount is. So the first step of the plan is to figure out how many assets they have that are preventing Roger from becoming eligible for Medicaid. So Roger, as the Medicaid applicant, is able to keep his personal property, a prepaid funeral policy, and $2,000 in his state of the $300,000 in cash assets. Nancy, as the well spouse, is able to keep the home, car, her personal property, a prepaid funeral policy, and then $137,400 of the $300,000 in cash assets. When we add the exempt assets or the non-countable assets of $2,000 plus the $137,400, their total exempt assets are $139,400. And when I subtract that from the total assets of $300,000, we calculate that the couple has a spend down amount of $160,600. The easiest way to achieve immediate Medicaid eligibility for this couple, because they didn't have a mortgage or other debt that they needed to pay, would be to eliminate the excess resources by purchasing a Medicaid compliant annuity for Nancy as the community spouse. Nancy would be the annuity owner, the annuitant, and the payee. And with Nancy being 83 years of age, she has a remaining Medicaid life expectancy of just over 8 years or 97 months. And because the annuity can only be structured for a whole number of months, then 97 months is going to be the longest term that we could purchase for her. But we could always shorten this to something less so that she receives the money back quicker, as long as it's within her Medicaid life expectancy. The payout on the annuity, if we structure the $160,600 over 97 months, is going to create monthly income of $1,725 per month for a total payout of $167,325. You'll see that the total payout is slightly greater than the amount going into the annuity, and this is just representing the principal plus the interest that the insurance company is going to pay back to the community spouse or to Nancy in this situation. The parties to the annuity contract, you'll see here that Nancy, as the community spouse, is going to be the annuity owner, the annuitant, and the payee. So she's going to receive all the payments back from the annuity without Roger being named as a payee on this contract. The primary beneficiary is going to be the state Medicaid agency to the extent that Medicaid benefits are provided on behalf of Roger. There are a few exceptions to this rule where the state does not have to be a primary beneficiary when the community spouse is purchasing the annuity. If there is a minor or disabled child, they are able to be listed before the state. And then also some state Medicaid agencies do allow for the Medicaid applicant to be listed as a primary beneficiary before the state as well. If you have questions about that, feel free to reach out. And then the secondary beneficiary or the contingent beneficiary in this case is usually the children, a trust, a charity, or whoever the community spouse wants to name as a remainder beneficiary. A lot of times we get questions about why Nancy as the community spouse would be the spouse that's purchasing the annuity and not Roger. The answer to that question is in almost all states other than Illinois and New York, the community spouse is able to have unlimited monthly income without the community spouse having to contribute any of their monthly income to the institutionalized spouse's cost of care. So there is no income limitation on how much the community spouse is able to keep as their protected income amount. If the annuity is purchased in the name of the Medicaid applicant and the income is not shifted over to the community spouse under the monthly maintenance needs allowance calculation, then the income that we're creating by way of the annuity is going to go towards the Medicaid applicant's cost of care or their patient liability. And the monthly maintenance needs allowance, or the MIMNA, is the minimum amount of income that the community spouse is entitled to. If the community spouse does not have enough of their own monthly income, then they're going to receive some of the Medicaid applicant's monthly income to bring them up to the amount of income that they should have under the MIMNA calculation. When we look at the income calculations here, we have to add Nancy's Social Security income of $1,000 per month, plus the annuity income, because Nancy is going to be the payee on this annuity contract, which means that her income total is going to be $2,725 per month. Nancy, in this case, we're assuming that she is going to receive the minimum amount of the minimum monthly maintenance needs allowance at around $22.88 per month. Because Nancy's income of $27.25 exceeds what the MIMNA amount is, she's not going to receive any of Roger's monthly income because she has enough of her own monthly income to meet what the MIMNA amount is. If she does have additional monthly expenses like paying for condo fees, if she has a mortgage, utility bills, things of that nature, then that $22.88, the MIMNA amount, can be increased to something more, up to around $3,500 right now is the maximum MIMNA amount. So in this scenario, we're assuming that she's going to be entitled to the minimum, but if she does have other living expenses that she needs to pay for, that amount may be greater than the $22.88. When we calculate Roger's copay to the facility, we're going to consider his monthly income from Social Security at $2,000. We're not going to shift any monthly income over to Nancy because she has sufficient income on her side. And so we're going to only be subtracting out Roger's personal needs allowance at $50 per month. This is going to allow him to buy personal items that Medicaid doesn't cover. So his patient liability or copay to the facility on a monthly basis is going to be $1,950 per month. The economic results of the 97-month annuity is that Roger and Nancy were expected to pay $10,000 a month for his care. We were able to reduce his copay down to $1,950 per month. So the couple's going to experience a monthly savings of just around $8,050 per month by qualifying Roger for Medicaid. The advantages of the Medicaid compliant annuity plan include that we were able to obtain immediate Medicaid eligibility for Roger without any kind of penalty period or private pay period. And we were also able to create sufficient monthly income for Nancy by way of the Medicaid compliant annuity so that she could continue living in the community. A potential disadvantage of the annuity is that if we structure the annuity over Nancy's full Medicaid life expectancy of 97 months, and she were to pass away during the 97-month annuity timeframe, the state would be entitled to recover against the annuity to the extent that they would provide Medicaid benefits on behalf of Roger. So a lot of times, in order to reduce the likelihood that the state would have a right to recover, the annuity would be shortened to a lesser time frame than the full Medicaid life expectancy of 97 months. The impact on the Medicaid compliant annuity when each spouse passes: Roger, as the Medicaid applicant, him passing away does not have any direct impact on the annuity policy because Nancy was named as the annuity owner, the annuitant, and she's the payee. But when Nancy, the annuity owner, passes away, the state Medicaid agency, as the primary beneficiary in most cases, will have a right to receive the amount that they provided on behalf of Roger in Medicaid benefits, and anything remaining in the contract would go to the secondary or contingent beneficiaries, which is usually children, a family friend, or a trust that would be listed as a secondary beneficiary. The timing or the steps that are involved to secure Medicaid eligibility by using a Medicaid compliant annuity: first, we want to know that the Medicaid applicant or the institutionalized spouse has actually entered a facility so that the snapshot date or the first continuous period of institutionalization has been achieved or established. And this is going to help maximize the amount of resources that the community spouse is able to keep. Once we have established the snapshot date, then we need to determine the spend down amount or the excess resource amount that needs to be spent down. Once that has been determined, we would purchase a Medicaid compliant annuity with any money that still needs to be spent down after we consider other debt that the family would have. And then after the Medicaid compliant annuity has been purchased, a Medicaid application is completed and submitted after that. So the first case study, like I talked about, is going to apply when the majority of the couple's countable assets are invested in after-tax dollars or non-qualified funds, such as checking, savings, CDs, or any account that has limited tax consequences for transferring ownership from one spouse to another. And the couple is also seeking immediate Medicaid eligibility. So now we're going to consider, actually we have a question here quick, let me answer that. So it says, the penalty period would only apply if Roger and Nancy had excess resources that they had transferred during the last 5 years. The penalty period would be the amount that is divided by the cost of the nursing home care. So in that scenario, Nancy and Roger would hope that they have enough assets to cover the policy amount during the penalty period. Can you run simple mathematical workout under this scenario? Yes, you are correct. So if the couple has made previous gifts or transfers within the last 5 years or the look back period that Medicaid currently has, then there would be a penalty period that would be associated to any gifts or transfers that have been made within the last 5 years. In order to determine what the length of the penalty period is, we would have to add up the total transfers or gifts within the last 5 years and divide that by the current divisor amount in your state, or the average cost of 1 month in a nursing home. And that would tell us what the penalty period would be. Depending on how far we are through the 5-year look back period, it may make sense for the couple to just continue paying for the 5 years privately before applying for Medicaid. But if it was something that just happened as far as a gift being made within the last couple of months, and the penalty period is only a couple months versus getting the clients immediately onto Medicaid, it's going to make more sense in that scenario to have the gifts returned if they're able to be returned, and do a crisis Medicaid plan at that point. So those are situations that we're able to help with the calculations as far as determining, does it make sense to just continue paying privately to get us past the 5-year look back period, or does it make sense to do a crisis Medicaid plan now? So great question. Getting back to the fact change here, if we have a Medicaid applicant that owns an IRA, in our original example, the couple has $160,600 that needs to be spent down, and those were all non-IRA accounts. So in that case, it made sense for Nancy as the community spouse to purchase a non-qualified or post-tax dollar Medicaid compliant annuity. But if we consider a situation where part of the $160,600 is the Medicaid applicant's IRA valued at $100,000, then we may approach the case a little bit differently depending on the life expectancy of Roger, and then also what state we're currently planning in. In this situation, the real problem asset is going to be Roger's IRA or qualified account, because most states are going to consider the Medicaid applicant's IRA or retirement account to be accountable asset that we need to spend down. And also the fact that we can't change ownership on his IRA over to Nancy without them paying the taxes on the full $100,000 IRA. That's going to be the most problematic asset that we're dealing with in a situation where we're trying to get one spouse on Medicaid and the majority of the spend down amount is currently being held in the Medicaid applicant's name in a qualified account. As you can see on the screen here, this is a map. All of the states that are in white on the map are states that consider the institutionalized spouse's IRA to be accountable asset. Most of the country does consider the institutionalized spouse's IRA to be accountable asset that we need to plan for. The states that are in orange on the screen are states that either completely exempt the IRA, or they will exempt the IRA as accountable asset if the Medicaid applicant is receiving systematic payments or their required minimum distribution under the IRS tables. When we do have an institutionalized spouse that owns accountable retirement account, we really have 3 different options. The first option is for the Medicaid applicant to liquidate the IRA, pay the taxes, and purchase a non-qualified annuity or a post-tax dollar annuity that's owned by the community spouse. In other words, the Medicaid applicant is going to pay all the taxes up front, and then they're going to shift the money over to the community spouse to purchase a non-IRA annuity. The second option is to do a direct IRA rollover or a transfer of Roger's IRA, purchase an IRA Medicaid compliant annuity that's owned by Roger, and Roger is also going to be the payee of the Medicaid compliant annuity. And then the third option is the name on the check rule, which is going to involve the same as option number 2, other than the community spouse is going to be listed as the payee instead of the Medicaid applicant listed as the payee. Under option 2 and 3, Roger is going to remain the annuity owner or the Medicaid compliant annuity owner because it would need to be a like-to-like transfer. He is the existing owner of the IRA, and if we do a 60-day rollover or a direct transfer of his IRA into a Medicaid compliant annuity that's owned by him, it's going to be considered a like-to-like transfer. That is not going to be a taxable event. If we look at option number 1, this is the option of the non-qualified annuity that's owned by the community spouse. So it's really similar to the first scenario that we already went through, where Nancy is going to be the annuity owner and the payee. But in order to get the money over to Nancy, we would have to liquidate Roger's IRA and pay all the taxes up front. Once the taxes have been paid, then the money is transferred over to the community spouse so that she is able to purchase a non-IRA or a post-tax dollar annuity. We're going to assume that the couple is going to pay around 22% tax on the $100,000 IRA based on their current income and the liquidation of his IRA. So after paying $22,000 in taxes on Roger's IRA, we would have around $78,000 net that would be able to be shifted over to Nancy to purchase a non-qualified or a post-tax dollar annuity. The couple is going to lose the $22,000 immediately by paying the tax bill. And after Roger liquidates the IRA, pays the taxes, now all of the couple's assets are post-tax dollars or non-qualified funds that can be transferred over to Nancy. In the beginning of the webinar, I referenced some situations that don't make sense for us to do Medicaid compliant annuity planning with. If we're looking at the couple having to pay $100,000 in taxes in order to get money from one spouse over to the other, and we only anticipate the Medicaid applicant to live for another, let's just say 5 or 6 months, it's not going to make sense to pay that $100,000 tax bill when they may only be spending $10,000 a month on nursing home care. So we want to take all of these things into consideration before just having clients liquidate retirement accounts in order to achieve Medicaid eligibility. Nancy can now purchase one non-qualified Medicaid compliant annuity that is similar to the first scenario that we went through. Nancy's after-tax Medicaid compliant annuity would be funded with the $60,600 that she has to spend down, and then also the $78,000, which was net of the $22,000 paid in taxes. In this case, the total that she would need to purchase the Medicaid compliant annuity for is $138,600. This is $22,000 less than our first scenario where we had $160,600 to purchase the annuity with. Because they're paying all the taxes up front, the amount that is remaining is going to be less. That is going to reduce the amount that needs to go into the annuity. If we structured her annuity again over her full Medicaid life expectancy, this would be a 97-month term, or we could shorten the annuity to something less than 97 months to reduce the likelihood that Nancy would predecease the annuity term. If we structure the annuity over the full 97 months, the monthly payout on the annuity is going to be less than the first scenario. It's going to be around $1,490 per month because there's less money going into this annuity because the taxes are paid up front. The parties to the annuity contract are going to be exactly the same, where Nancy is the owner, annuitant, and the payee. the state is likely going to be the primary beneficiary, and children, a trust, family, friends, or a charity would be listed as the secondary beneficiary. The income calculations in this situation are very similar to our first case study, where the total income is $24.90 per month, which is still greater than what Nancy's monthly maintenance needs allowance is. So she again is not going to receive any of Roger's monthly income. So his copay to the facility is going to be his Social Security of $2,000 less his $50 personal needs allowance, or $19.50 per month. The economic results are going to be exactly the same as our first scenario, where they're going to immediately start saving around $8,050 per month on Roger's care. The advantages and disadvantages of option number one, or paying all the taxes up front, is the advantages are that this is a safe option. We know that Medicaid accepts this type of strategy, and Roger is able to immediately become eligible for Medicaid. The disadvantages are that the couple is going to pay the $22,000 in taxes up front. So like I talked about, we need to consider the break-even time frame. If the tax consequences are so large and we don't anticipate the client outliving whatever that time frame, the break-even time frame is, it may make sense to not liquidate the retirement account and simply just privately pay for whatever the time frame that the Medicaid applicant lives for. With Nancy's monthly income exceeding her monthly maintenance needs allowance in this situation, she's not going to receive any of Roger's monthly income, and a portion of their Social Security benefits may become taxable because we are liquidating a large IRA, paying the taxes, and that may also increase what their Medicare premiums are for the following year if we liquidate a large IRA account like this. The second option to consider when the Medicaid applicant owns an IRA is to have an IRA Medicaid compliant annuity owned by the Medicaid applicant, and also have them named as the payee. So rather than liquidating Roger's $100,000 IRA and paying all the taxes up front, Roger can use the $100,000 IRA to purchase a Medicaid compliant annuity that is structured over his Medicaid life expectancy. And by converting his liquid IRA of $100,000 into a Medicaid compliant annuity, his IRA is no longer going to be considered a countable asset or an available asset by Medicaid. Now it's just going to be considered an income stream, but it will be considered to be spent down by converting it into an income stream. In this scenario, we're going to have to purchase two separate annuities, one for Roger and one for Nancy. Roger's IRA would be transferred through a direct transfer or a 60-day rollover into an IRA Medicaid compliant annuity. Nancy must also purchase an after-tax Medicaid compliant annuity to spend down the remaining $60,600, because we're not able to mix pre-tax dollars and post-tax dollars in the same Medicaid compliant annuity, because the payments on the contracts are going to be taxed differently. So in our first scenario, Nancy could just purchase one annuity because taxes were paid up front and all of the money was considered to be after-tax dollars when she purchased her annuity. In this situation, with Roger being 85 years of age, his remaining Medicaid life expectancy is just at 6 years or 72 months. If we structure his annuity for 72 months and $100,000 is used to purchase the annuity, the monthly payment is going to be $1,435. The total payout is a little bit more than the $100,000 going in. Nancy would then purchase a second non-qualified annuity for $60,600 over her Medicaid life expectancy of 97 months, which is going to create monthly income of $650 each month for her. The parties to Roger's IRA Medicaid compliant annuity, Roger is going to be the annuity owner, the annuitant, and the payee, since it's his IRA that we are converting into an IRA Medicaid compliant annuity. It would need to be a like-to-like transfer of Roger's IRA into an IRA that's owned by Roger. The primary beneficiary in this case is going to be Nancy, because Nancy is the community spouse, and a community spouse is always able to be named as a primary beneficiary before the state Medicaid agency. The contingent beneficiary in this case is going to be the Medicaid department, to the extent that they're providing benefits on behalf of Roger. And then the tertiary beneficiary in this case is usually going to be the children, a trust, or a charity that would be named as the third beneficiary. The parties to Nancy's non-qualified annuity are going to be exactly like we've talked about before, where she's the owner, annuitant, and payee, and the state Medicaid agency is the primary beneficiary, with the children, a trust, or a charity listed as contingents. The financial impact of this plan of doing two separate annuities, where Roger is the payee on one annuity and Nancy is the payee on the other, is that Roger's monthly income is going to increase from his Social Security of $2,000 up to $3,435, because we're adding his annuity payment plus his Social Security. Nancy's income is also going to increase from her receiving just $1,000 a month of Social Security up to $1,650. If we assume that her monthly maintenance needs allowance is still going to be the $22.88, she has a monthly shortfall in this case of $638.75. She now is going to receive a portion of Roger's monthly income, because she does not have enough monthly income of her own to bring her up to the $22.88. So Roger's copay to the facility in this case is going to be $2,746.25 after we consider the amount of income that he has, the shifting of income over to Nancy, and then also the $50 personal needs allowance that he's going to be entitled to. This again is just showing you the income calculations that we are adding $650 to Nancy's monthly income from her annuity, and then also considering the $1,435 that Roger is going to have from his Medicaid compliant annuity, because he's the payee on the contract. And you see that his copay to the facility is going to be $2,746.25. The economic results of doing two separate Medicaid compliant annuities is that the couple was expected to pay $10,000 per month for Roger's care. We were able to reduce that copay down to $2,746. So they're going to immediately experience a monthly savings of around $7,300 by doing two separate annuities, and they're not paying all the taxes up front by going with option number 2. The advantages of option number 2 is that, again, this is a safe option. We know that Medicaid accepts this strategy by naming Roger as the payee on his IRA Medicaid compliant annuity. Roger is immediately eligible for Medicaid, and Nancy is able to be the primary beneficiary of Roger's annuity. We were able to create around $22.88 per month of income for Nancy by way of the Medicaid compliant annuity, and then also the shifting of income from Roger over to her under the MIMNA calculation. They're going to pay limited federal income taxes because they're not liquidating his IRA at $100,000 and paying the $22,000 upfront. And then their Social Security income and their Medicare benefits are likely not going to be taxable or affected by doing option number 2, just converting the retirement account into an income stream. The disadvantages of option number 2 is that if Nancy's monthly income exceeds her MIMNA, she's not going to receive any of Roger's monthly income. So we're actually increasing Roger's copay to the nursing home by purchasing a Medicaid compliant annuity in his name if we're not able to shift that income over from Roger to Nancy under the MIMNA calculations. Now the final option is to use name on the check rule, where this is the same as option number 2, other than the payee of Roger's annuity would be Nancy instead of Roger. Name on the check rule is strictly a Medicaid concept, which stands for the idea that income belongs to the person whose name is on the check. This is not an IRS rule, and it can't be found in any IRS rule or regulation. And so we're able to use this type of rule only for Medicaid planning purposes. But if we're looking for any type of IRS rule or documentation that is going to support naming another person as a payee on a retirement account, we're not going to find that type of documentation within the IRS rules. The rule is used in married couple cases when the institutionalized spouse owns a qualified account that must be spent down in order for the Medicaid applicant to gain Medicaid eligibility. And like I said, the only difference between option 2 and 3 is that the community spouse is named as the payee of the Medicaid applicant's IRA Medicaid compliant annuity. Roger is still going to annuitize his $100,000 IRA. He's going to name Nancy as the irrevocable payee instead of naming himself as the payee on his IRA Medicaid compliant annuity. The payment amount is going to be the same at $1,435, and instead of Roger receiving the payments from the annuity contract, Nancy is going to be named as the payee, and she is going to receive the check each month with her name on the check. Structuring the annuity, everything is going to be the same as under option number 2, other than you see that on Roger's annuity, Nancy is going to be named as the payee under option number 3 versus option 2. Roger was the payee on his contract. The parties to Roger's IRA Medicaid compliant annuity, again, Nancy is going to be the primary beneficiary, and in this situation, she's also going to be listed as the payee of the annuity payments. The parties to Nancy's non-qualified annuity is going to remain exactly the same as what we've been talking about. The financial impact of option 3 is that Roger's monthly income is going to remain at just Social Security of $2,000 per month because Nancy is the payee now on both annuity contracts. Nancy's total monthly income is now going to be $3,085 when we consider the 2 annuity payments and also her Social Security income at $1,000 per month. So her income now is exceeding her monthly maintenance needs allowance of $2,288. She's not going to receive any of Roger's monthly income, so his copay to the facility is going to be $1,950 when we consider his Social Security less his personal needs allowance at $50 per month. You'll see in this slide all of the annuity payments plus Social Security are all going to be on Nancy's side of the equation, so that her monthly income is $3,085, which is exceeding her MIMNA at $2,280, and that's where we're getting the $1,950 for the copay amount that Roger is going to pay. The economic results is that we're able to reduce the copay down to $19.50 per month, and the couple is going to experience a monthly savings of $8,050 per month. The advantages of this plan are going to be similar to option number 2, other than Nancy is now going to have monthly income of $3,085 per month to meet her needs. This is greater than option number 2, where she had $22.88, or she had the MIMNA amount that she was receiving on a monthly basis to help meet her needs. Whereas, so in this case, her income is more than option number 2. The main disadvantage of option number 3 is that this is a risky strategy. There are more state Medicaid agencies that are challenging the name on the check rule, and they will either consider the income to belong to the Medicaid applicant, or they can consider the annuity purchase to be an uncompensated transfer that would trigger a penalty period. And so this is something that you would want to make sure that has been done in your state before, or is something that your state honors as far as using name on the check rule before doing this type of planning with a retirement account. This map here is showing you some states that, the states that are in orange have had favorable decisions related to name on the check rule. The states that are in black have had unfavorable decisions. And then the states that are in white on the screen, there's only 2 of them that have had kind of mixed outcomes. Sometimes the case has been favorable using name on the check rule, and others it has not. So in summary, when we're considering option number 2 or option number 3, it really comes down to, does your state allow name on the check rule? And then also we have to consider what the community spouse's monthly maintenance needs allowance is, because if we annuitize the Medicaid applicant's retirement account and we name them as the payee, the Medicaid applicant as the payee, and they're going to shift that income over to the community spouse anyways under the MIMNA calculation, then there wouldn't be any need to even try using name on the check rule. So we have to consider how much income is going to be created by way of the annuity, and then also what the community spouse's MIMNA amount is, because it may make sense to just do option number 2 and shift that income over to the community spouse that way as well. And it looks like we have a couple minutes left. I can answer questions if anybody has them. Looks like we have a couple. There's a question here. It says, Roger has dementia. Would Nancy have any trouble using a standard power of attorney to conduct the rollover of Roger's IRA? The answer to that is many times if the Medicaid applicant is the owner of the retirement account, the current custodian will accept a power of attorney in order to either liquidate the retirement account and pay the taxes and send a check over to send a liquidation check, or they will initiate a direct transfer using the power of attorney and transfer the money directly from the current custodian over to the company that would issue the Medicaid compliant annuity. So in cases like that, we would just have to make sure that the power of attorney document is actually on file with the current IRA custodian, and that they're acknowledging that they have that document and that somebody else can sign the transfer paperwork or the liquidation paperwork in order to either liquidate or transfer the retirement account. Okay, somebody commented saying, Seems like option number 3 is the best option, more income to the spouse, less payments to the nursing home. That is correct as long as your state does honor the name on the check rule. There's another. And then there's another part of this question here. It says after the annuity is done paying out and the person outlives the annuity, the nursing home just gets Social Security for however long that person has to live. Yes, once the annuity is done paying out, then the copay to the facility is going to reduce down to just Social Security less the $50 personal needs allowance or whatever the personal needs allowance is in your state. And I think that's all of the questions that I'm seeing here. If anybody has questions after today's program, feel free to reach out to me either by phone or email that you're seeing on the screen. I want to thank everybody for joining us today. Next month, we're going to have Attorney Todd Watley talking about common Medicaid mistakes that are made when applying for Medicaid. So please join us for our July webinar. And I thank everybody for being here today and take care. Thank you.